Thank you very much, member. Recognizing the member from Langley, Willowbrook.
Thank you, Honourable Speaker. I rise today to speak on Bill 10, Labour Statutes Amendment Act, on behalf of the residents of Langley, Willowbrook. As a member of the Conservative Party of British Columbia, it is always a pleasure to stand in this chamber and speak on bills that will shape the rules governing workplaces across British Columbia. The laws we pass here affect the daily lives of millions of workers and employees throughout our province. They influence how businesses operate, how employees are treated, and how disputes are resolved when things go wrong. At the outset, I want to be very clear about something that should unite all members of this House, Mr. Speaker. Workers deserve to be paid what they are owed. The entire purpose of employment standards law is to ensure that wages earned are wages paid. Those principles are fundamental to the Employment Standards Act, British Columbia. They are principles that every member of this chamber should support. When someone works hard, shows up for their shift, and gives their time and energy, and fulfills their responsibilities, they should have confidence that they will receive the wages they have earned. That is not a dispute statement. It is a basic requirement in any fair and functioning economy. At the same time, Mr. Speaker, we must recognize that healthy workplaces require balance. Workers need strong protections, and they deserve clear mechanism to recover wages or resolve disputes. When problems arise, but employers also need rules that are fair, predictable, and workable. Across British Columbia, and especially in the communities I represent in Langley, Willowbrook, small and medium-sized businesses are the backbone of the local economy. These businesses are often family-owned. They are the restaurants, construction companies, retail shops, and restaurants, and service providers that create jobs and help communities thrive. Most of these employers want to do the right thing. They want to treat their employees fairly. They want to follow the law, and they want to maintain positive relationships with the people who work for them, especially the foreign workers, as they become their families here. Our labor laws must recognize that reality. They must hold bad actors accountable, but they must also support the vast majority of responsible employers who are trying to follow the rules. The bill before us today proposes a number of changes to the Employment Standards Act, as well as the Temporary Foreign Workers Protection Act, BC. Some of these changes are administrative or technical in nature. Others introduce new processes or modify existing enforcement. As legislators, it is our responsibility to carefully examine these changes, understand their implications, and ensure they serve the best interests of workers, employers, and the broader economy. One of the changes included in this bill relates to the handling of wages owed to employees who cannot be located. Under the previous rules, the director was required to attempt to locate the employee for a period of 1 year before taking possession of those wages. Bill 10 removes that 1 year waiting period. Under the proposed changes, if reasonable efforts have been made to locate the employee and those efforts are unsuccessful, the wages may be transferred to the administrator sooner. The goal here appears to be administrative effectiveness. Unclaimed wages can be secured and managed rather than remaining in limbo for an extended period of time, Mr. Speaker. In principle, ensuring that money owed to workers is safeguarded makes sense. Workers should always be able to claim the wages they have earned hardly. However, Mr. Speaker, the more major and potential dispute aspects of this bill related to the appeals process and the introduction of new requirements for employers who wish to challenge demonstration made under the Employment Standards Act. Under the proposed changes, if an employer wishes to file an appeal of a determination that requires payment of wages or other fiscal amounts, they must deposit the amount owed with the director before the appeal can be processed. In other words, Mr. Speaker, the money must be paid up front, simply to access the appeal process. The legislation does provide some flexibility. The panel may, on a case-by-case basis, determine that a lesser deposit amount is appropriate, but the defect requirement remains the full amount must be deposited before the appeal can move forward, Mr. Speaker. On the surface, this may appear reasonable. After all, if wages are owed to workers, it makes sense that the funds should be secured while the appeal process unfolds. But we must consider the practical suggestion of this requirement, particularly for small businesses, Mr. Speaker. Larger corporations may have the financial resources to deposit major sums of money while pursuing an appeal, but small and medium-sized businesses operate on tight margins. Cash flow can be unpredictable. Unexpected expenses can have serious consequences, Mr. Speaker. For a small business owner who believes a determination is incorrect, requiring the full amount to be deposited upfront may effectively prevent them from exercising their right to appeal. This raises an important question about access to justice within our employment standards system. Appeal exists for a reason. They allow decisions to be reviewed and corrected if errors have occurred. They provide an important safeguard within regulated framework. If the financial barriers to filing an appeal becomes too high, some employers may simply be unable to challenge decisions they believe are wrong. Mr. Speaker, fairness in the system must apply to everyone involved. Workers deserve fair treatment and timely solution of their complaints, but employers must also have fair opportunity to present their case and seek review when necessary, Mr. Speaker. Mr. Speaker, another aspect of Bill 10 introduces a new complaint resolution process during investigations. The Director may require parties to take part in this process while the investigation continues. The intent appears to be encouraging early solutions of disputes, potentially reducing the need for lengthy investigations or formal determinations. In theory, Mr. Speaker, alternate dispute solutions such as mediation can be beneficial. They can provide opportunities for parties to reach mutual acceptance solutions without prolonged legal processes, which can also be very expensive. However, we must again consider the practical realities faced by many small business owners. Mr. Speaker, large organizations often have dedicated human resources department and legal counsel who can manage complex employment disputes. But Mr. Speaker, small business owners rarely have those resources. For many small business owners, navigating employment standards complaint is already a challenging and time-consuming process. Adding mandatory mediation or additional procedural steps may increase administration burdens and create further complications. If these processes are implemented without accurate support or guidance, they could place additional strain on employers who are already trying to comply with complex regulated requirements. Mr. Speaker, perhaps the most major concern surrounding this bill relates not only to the specific changes being proposed, but also to the broader context in which they are being introduced. For several years now, the Employment Standards Branch has faced major challenges in the processing complaints in a timely manner. Workers who file complaints often wait months, sometimes far longer, Mr. Speaker, before these cases are resolved according to the government's own service plans. Over the past 4 years, only 32% of employment standards complaints have been resolved within 180 days, Mr. Speaker. That means the majority of workers are waiting longer than 6 months for solutions. For someone who believes they have been denied wages they have rightfully earned, 6 months is a long time to wait, Mr. Speaker. In many cases, the money owed may represent rent payments, groceries, childcare expenses, or other essential costs. Delayed enforcement undermines the effectiveness of employment standards law. A system designed to protect workers must be able to respond quickly when problems arise, and not 180 days. The government has recognized this issue and has set a target of resolving 80% of complaints within 180 days by 2027-2028 fiscal year. But even if the target is achieved, 1 in 5 workers could still be waiting more than 6 months for a solution. Mr. Speaker, we should also ask ourselves whether that standard is truly acceptable. More importantly, we should ask whether this bill changes alone will solve the problem of delayed complaint. The provincial budget currently freezes funding for labour programs at approximately $22.3 million for the next 3 years. In fact, that amount is slightly lower than the previous year's estimated spending of $22.85 million. Mr. Speaker, at the same time, the government expects complaint solutions times to improve majorly. Those outcomes raise serious questions about whether the Employment Standards Branch has the resources necessary to meet these targets. Mr. Speaker, if we want complaints to be resolved faster, the branch responsible for investigating and enforcing employment standards must have accurate staffing, proper training, and the tools needed to do its job effectively. Without those resources, the bill changes alone may not produce the improvements workers and employers both want to see. Another issue that has been raised by stakeholders across the province related to consultation. Many employer organizations have indicated that they were not meaningfully consulted before these changes were introduced. Mr. Speaker, labour policy, perhaps more than any other area of law, benefits from broad consultation. Workers, employers, labour organizations, business associations, and legal experts all have valuable views to add to this. When policies are developed through inclusive consultation, they are more likely to reflect real-world conditions and practical considerations. Mr. Speaker, when stakeholders feel excluded from the process, it can undermine the confidence in resulting legislation. Mr. Speaker, it is important to remember that the labour laws are not an abstract policies. They govern relationships between people, between workers and employers who rely on each other every day. Effective labour regulations should strive to promote cooperation, fairness, and clarity. It should provide clear outcomes and a reliable process for resolving disputes, Mr. Speaker. In the riding of Langley, Willowbrook, I regularly speak with small business owners who are deeply committed to their employees. They sponsor local teams, they donate to community organizations, they provide opportunities for young people entering the workforce for the first time. These businesses are not faceless corporations. They are run by families and individuals who care about their communities. Mr. Speaker, when we design labour policies, we must ensure that it reflects the realities faced by these employers, while still protecting workers from unfair treatment. The goal should always be balance. Workers must have a confidence that if they are denied wages or treated unfairly, there's a system in place that will protect them and help them recover when they are owed. Employers must also have confidence that the system is fair, transparent, and accessible, and that they will have the opportunity to challenge decisions they believe are incorrect. Mr. Speaker, legislation like Bill 10 plays an important role in shaping that balance. That is why it is essential for the House to carefully examine each provision and consider its potential impacts. Mr. Speaker, some elements of this bill may improve administrative effectiveness or clarify existing processes. Others may introduce new challenges that need to be addressed through amendments. Additional resources or improved implementations strategies. As members, our responsibility is not simple to pass laws, but to ensure that those laws work in practice and work for everyone in BC. Mr. Speaker, that means asking difficult questions. It means listening to stakeholders, and it means recognizing when additional support or adjustments may be necessary. Speaker, the people of British Columbia expect their government to create a fair and effective labour system. They expect workers to be protected, employers to be treated fairly. They also expect disputes to be resolved in a timely manner so that problems do not drag for months or years. Ultimately, the success of employment standards bills should be measured not just by the number of files processed or timelines reported in service plans, but by whether workers actually receive the wages they are owed and whether employers have confidence in the fairness of the system. As this bill continues through the process, I hope this government will carefully consider the concerns raised by employers, workers, and community members across the province. I hope they will ensure the Employment Standards Branch has the resources it needs to enforce the law effectively, and I hope I will remain open to improvements that strengthen fairness, transparency, and balance within our labour system. Mr. Speaker, the residents of Langley Willowbrook want a labour system that works. They want laws that protect workers while supporting reasonable employers. They want policies that are developed through meaningful consultation and implementation with the resources necessary to make them effective. Those are reasonable reaches that the community wants, and they are the requirements that every member of this House should strive to meet. Thank you, Mr. Speaker.